Welcome. I'm Sean Wilkerson, Innovation Development Program Manager here at the United States Patent and Trademark Office. I want to thank you today for joining us for the Women's Entrepreneurship Symposium. We're excited to have you here for the third in our series of discussions held every Wednesday in March celebrating Women's History Month. Before we start the panel, Resources for Protecting Your Intellectual Property, I have a few housekeeping notes to go over. The agenda for today's program is in the inbox of everyone who registered for the program, but it can also be found online at www.uspto.gov. During the panel, we will be accepting questions for the panel. If you'd like to send us your question, you can do so by email at wes@uspto.gov. We'll do our best to get to all of your questions at the end of the panel. If for any reason you get disconnected during the presentation, you can log back into the program at any time using the link that brought you here. If you miss a portion of the program, don't worry. We will be posting this program online in a few weeks on our website at uspto.gov. However, if you want to review the information immediately after the program, you can do so on Facebook. We will be streaming live on Facebook, so after the program, the video will be posted and available to you if you want to go to the USPTO presence on Facebook. Now, at this time, I would like to introduce you to our moderator for today's program, Heidi Kelly, Tech Center Operations Manager here at USPTO. Kelly? Heidi, I'll let you take it from here.
Good afternoon, and welcome to the Women Entrepreneurship Symposium panel, Resources for Protecting Your Intellectual Property. As Sean mentioned, my name is Heidi Rivera Kelly. I am currently Technology Center Operations Manager at the U.S. Patent and Trademark Office with the Chemical and Materials Engineering Technology Center. Prior to this assignment, my everyday task was being a supervisory patent examiner, where I manage a team of examiners, chemists and chemical engineers in the area of liquid purification and gas separation, which in everyday terms is essentially the area of filtration. I look forward to moderating this panel with the hope that we will provide you with an informative discussion on intellectual property resources as you work and plan to protect your intellectual property. Without much ado, I would like to do a cursory introduction of our panelists and then turn it over to them so they can let you know more about their backgrounds and overview of how they and their agency support intellectual property and small businesses. We have on our panel today Jason Lott. Jason is Attorney Advisor, Trademark Customer Outreach at the USPTO. We next have Jennifer Shih, who is the Chief Scientist and Program Manager with the Office of Innovation and Technology at the U.S. Small Business Administration. We also have Jennifer Hirsch, who is the Staff Attorney with the Office of Enrollment and Discipline at the USPTO. And we also finally have Benjamin Hardman, Senior International Trade Specialist with the Office of Standards and Intellectual Property, Industry and Analysis at the International Trade Administration at the U.S. Department of Commerce. I turn it over to you, Jason, for your introduction.
Thank you very much, Heidi. Hey there, everybody. My name is Jason Lott. I am the Attorney Advisor for Trademarks Customer Outreach here at the USPTO. And really, that's a long way of saying that it is my job to teach you about trademarks, what they are, why they're important, and how a federal trademark registration can help you build your business. I've been with the agency since 2000. I originally got hired straight out of law school and have been here for quite some time. I originally started off as a trademark examining attorney, which means that when you would submit your application to register your trademark, I was one of the folks who would take a look at it. And I did that for many years. And then maybe about around 2009, 2010, there was a work project opened up to create a video to help applicants just like you avoid some pitfalls in filing a trademark application. Well, that one video has now become about 30 different videos, and I have transitioned from being an examining attorney into doing outreach on a permanent basis. So my day trying to help folks just like you learn about trademarks, or try and find better ways to educate and better ways that we can improve our materials to help you learn. So what we do at the office on the trademark side of the USPTO essentially is register trademarks. That's what our mission is. And we would love nothing more than to be able to have you register your trademark with us. And so everything we do is based around that. So protection of brands. So you being able to protect your brand. That's what we do on the trademark side of the USPTO.
Great. Hi, my name is Jennifer Shee, and as Heidi mentioned, I'm the Chief Scientist and Program Manager for the Small Business Innovation Research Small Business Technology Transfer Programs out of the U.S. Small Business Administration. And so, a little bit about myself. I actually come from a technical background as well. My PhD is in neuroscience, hence the brain. But I've been with the federal government for a number of years. Really, what we do at SBA is help you innovators, entrepreneurs start small businesses and grow, and really you're the engine of the U.S. economy. So that's our mission here at SBA. With the Small Business Innovation Research, Small Business Technology Transfer Programs, it's kind of known as America's Seed Fund. It's about $4 billion of non-dilutive funding to go to support innovations and research and development that's being done at small businesses, get out of just being an idea, a discovery in a lab, and actually get out onto the marketplace. And so this is money that comes from across the entire federal government. SBA actually doesn't have any of that R&D money. And so our job and our role within the SBIR, STTR programs is to help set the policy and coordinate and make sure that you as a small business owner or a future entrepreneur knows how to access that money. How do you get to that capital? How do you understand and find advice and counseling? And also another key part of the SBA is in supporting small businesses in getting the government as a customer through small business contracts. And one part that you may now know much more about that was hidden before was that SBA plays a very vital role in providing disaster assistance. And so I'm really looking forward to this conversation. As it relates to intellectual property, small businesses, that's the way to really commercialize that IP. Start a company and get out there and get it out onto the marketplace. So thank you. Looking forward to this conversation.
Hi, my name is Jennifer Harchick. As Heidi mentioned, I am an attorney in the Office of Enrollment and Discipline at the U.S. Patent and Trademark Office. Prior to coming to the office, I was an attorney in private practice where my focus was on all types of intellectual property, prosecution and litigation. So I assisted individuals, small businesses, large businesses in obtaining patent, trademark, and copyright rights. Now at the office, I have many different roles, but one of the roles, and that we're going to be talking about today, is on the pro bono side. So the U.S. Patent and Trademark Office is very supportive of intellectual property rights and supporting small businesses and innovators. Two of the programs that our office oversees is the Law School Clinic Certification Program and the Patent Pro Bono Program. Both of these programs we're going to be talking about in more detail as we go on throughout this event, but they both provide intellectual property services to the public free of charge for qualified individuals. So I'm excited to continue on in helping to promote innovation and businesses through the Patent Trademark Office's programs that help to support pro bono and overseeing these two programs. Thank you.
Hi, everyone. Thank you to Heidi and Sean and the PTO for the wonderful invitation to sit on this panel. My name is Ben Hardman, and I have been invited to speak on this panel because I have the great honor of running the Stop Fakes program. So I'm going to tell you about the resources we have and the outreach that we do. The mission of Stop Fakes is to give information to consumers and businesses about protecting intellectual property. So we do this in a number of ways. We do this through roadshows, direct outreach to the public. Our main function is kind of bringing together all of the assets that the US government has and trying to put it in one place for businesses to get to. So I'm happy to be on this panel with scientists and other attorneys, so honored to be here. And the layout of my office where I work out of is still under the Department of Commerce, but through the International Trade Administration, we have an Office of Standards and Intellectual Property. So we kind of work as the office for giving advice on IP to the International Trade Administration, and of course work closely with the PTO. And so happy to be here, happy to talk about the program, and look forward to the discussion.
And we're happy to have all of you with us here today. So we'll start off our discussion from a hypothetical perspective. We'll start with a hypothetical perspective of a business owner. So let's say this individual has a great idea or concept, and this person may even have a prototype of what they consider to be like this novel invention, which, you know, she's worked on for who knows how long. So for example, you know, this hypothetical inventor may not realize it, but they may have access to, for example, the Patent and Trademark Resource Centers, which are essentially a network of public, state, and academic libraries designated by the PTO as locations to provide assistance to the public in the areas of patent and trademark, for example. Our business owner and budding inventor, in this case, if they approach the PTRC, can have a librarian assist them on searching historical data on patent and trademarks. One of the benefits of these libraries is that they would have access to databases similar to the ones that examiners use when they are searching invention and submitting applications. So they can find out on their own, using looking at their prototype, using descriptors. They can see historically what has been done in the area that they're interested in. So this is one option for a starting point, but I'd like our panelists to expound a little bit on, starting with you, Jason, on what resources at the onset or at this point should our hypothetical business owner have in the area of trademarks, for example, and then we'll go on to our other panelists.
Sure. Well, I'll tell you what, let's do, Heidi. Let's take you, let's say make you the hypothetical inventor, okay? And let's say, and I don't know, you might be, let's say you're a total gearhead and you're working on inventing a new sort of motorcycle, right? One that hovers off the ground. No one has ever seen this before, right? And you got your prototype in your garage. Okay, great. So what are you going to do now that you have this piece of intellectual property? What are you going to do with it? Well, you might consider starting a business. And so one of the things when you're starting a business, one thing to think about is your trademark. And essentially what that means is, what is the sort of brand that you have for your particular good or your particular service, right? Maybe it's a brand name, maybe it's a slogan, maybe it's a logo, maybe it's a combination of all of those things. And what we're really talking about is, how do people find you in the marketplace? Right? What is the name of the thing? What is the brand of the thing that you are selling or the service that you're providing? And that's the most important thing, because your public has to be able to find you, right? So how are they going to be able to find you online when they type something into Google. They're typing hover cycle or Heidi's hover cycle or something like that, right? That's how they find you. That's how you advertise. And it's, when you're actually selling the thing, maybe it's the brand that you're putting on the actual product itself, right? So what we're talking about is a brand. And that really, in a lot of ways, is your trademark, because it's how people find you. And so even though you're at the very beginning stages of beginning your business, you need to already be thinking about what that trademark is, what that brand name is, because you want to lock it down early on, because if you think about your business suddenly taking off and growing, you don't want to be at a place, a couple of years down the road where you're like, oh yeah, man, what was the, I should have really come up for a name for that thing, and because by that point, other people might be calling their thing a similar name, or somebody else might start a competitive company that's just kind of like yours and is kind of coming up with a name that's sort of like yours. You don't want to have that happen, right? You want to protect your trademark, your brand name, your slogan, your logo, whatever it happens to be that identifies you as the source of Heidi's hover cycles, right? You want to lock that stuff down early so you can prevent your competitors from sort of trading on your good name later on as your business continues to grow. So one of the first things you're going to want to do is figure out, what is the brand name that I want to protect? How are people going to identify me in the marketplace? And then you can do that research to find out, is this actually a new name, or is it going to be too close to somebody else, right? Because what you want to be able to do is have your trademark and then protect it here at the USPTO with us, right? You want to have your brand name and then file for federal trademark registration in order to get nationwide protection for your mark. And one of the ways to do that is once you file, the examination that's going to take place is we are going to look at that application and say, is anybody else out there using a same or similar mark for related goods and services? So what you can do before you even file, and maybe before you even lock down in your own mind exactly what your brand and your trademark is going to be, you can do the search. And as Heidi mentioned, you could talk to the folks at a PTRC. You can even do the search yourself, because we have the Trademark Electronic Search System, which is our database. It is publicly accessible 24/7 on our website, and you can use our database and look to see, is anybody else out there using Heidi's hover cycles, right, for motorcycles that, float off the ground. So you can do that search beforehand. And you can also use the internet, obviously, to look to see, is anybody else out there? Because maybe it turns out, let's say that you're based in Virginia, and it turns out that somebody in Arizona is already coming up with something else that's very similar with a very similar name. Well, you might want to rethink calling your thing Heidi's hover cycles and come up with a different name, because you don't want to run into sort of competition with that other guy in Arizona with the motorcycle that he's creating. Right? So you want to start doing that research early on in the beginning of the business to make sure you're not going to come up with something that's going to sort of compete with other folks in terms of a brand name, and that might confuse consumers when they encounter both of your goods in the marketplace. So that's a lot of the work that you want to do early on before you even get to the point where you're trying to register your trademark with the USPTO, is you want to be thinking about the trademark itself and doing as much research as you can and as much learning as you can to understand trademarks. And we have lots of resources that are available on the uspto.gov website, in addition to other things that we do. And we can get more in depth into those later on, or I can talk about them now, Heidi, if you want to, if you want me to. But those are the sorts of things you want to do early on in the process, is like figure out what your trademark is going to be, and then figure out, is this something that I can protect? And if so, what are the steps that I need to take in order to get federal protection for that trademark?
Well, Jason, since we're on the topic, can you let them know where they would go to search?
Yeah, sure. So if you go to uspto.gov, you will click on, and if you go to our homepage, you will see a section that's for trademarks. Actually, you know what? There's an even easier way, right? I was going to take you into the trademarks landing page, and then you can find it on the landing page. But one of the easy things to do is actually on our website. I believe it's on the right-hand side of the screen. There's a little box called Find It Fast. And in the Find It Fast box, there's a section for patents and there's a section for trademarks. And if you click on trademarks, it'll have a little tiny drop down. And one of the things you can drop down and you'll look for TESS, T-E-S-S. That's the Trademark Electronic Search System. And so you can easily click to it from the homepage of uspto.gov.
Thank you, Jason.
Sure.
Jennifer Shi, can you speak? So we have our hypothetical person. They are now thinking about a trademark, and they're also thinking, well, I definitely want to start a business. And so they're looking to maybe the SBA. And if they're not, can you tell them what help the SBA would provide at the start of the process for somebody in this position?
Yeah, and actually, you know, I really appreciate hearing that perspective, Jason, because I actually coming from, so I have two diverging thoughts, and so I will, but it makes me think of, you know, the list of band names that I keep in my phone. So having some good trademark names so that you don't do all of this work and effort to build up a product, do all the research to develop your invention, and then create a business, and now somebody tries to find you. Yeah. So how are you going to sell it? So if you do want to start a business, so I'm going to go down two different tracks here. One is actually just thinking about on the invention side of things. So putting on my scientist hat, and if I just came up with an invention, I have a prototype, I may not actually know. I would think that I wouldn't want to yet name it something. And it's really about kind of trying to figure out my invention and that customer, like what's the market going to be, so that I can really think carefully about what it is, how it is I want to be known. And so if there still needs to be more research and development done to actually turn this, maybe it's a prototype, into a full product, you know, there's definitely the program that I was talking about, the Small Business Innovation Research, Small Business Technology Transfer programs, and thinking about how to use that to really continue the R&D for the full development. But on the business side, you know, once you've got an idea, you want to protect it. And so you want to think about how to make sure that you can both develop and protect at the same time. And there are so many different factors that go into creating a successful business and launching a product. And one of the key things to know, I think, is you are not alone. And there are many experts out there in all these different facets of creating a business, of thinking through the research and development side, of thinking through the marketing and planning side. And the Small Business Administration has resources to help you run the gamut of how you actually get registered as a business. What are some of the things you need to do? So one of the core pieces is, you know, we as specifically within the SBA, we can't help every single person in the country directly ourselves. We want to, but we just can't reach everybody. And so the key way we do reach everybody is by making sure that we fund resource partners. And I do want to put a call out, because today is actually SBDC Day, which is the Small Business Development Centers. And they are a huge key resource. There are over 980 small business development centers across the entire country that are there to help you figure out what do you need to do to get started to actually create a business. And once you have a business, what are you going to do to develop your business plan? There are also SBA funds an organization called SCORE. It used to be an acronym that stood for something specific and now has become known as just SCORE. So I don't even want to say exactly what it stood for, because I don't want people to think that, but SCORE is this mentoring network. And so it's the nation's largest network of volunteer business mentors that have knowledge and experience about starting businesses from all sorts of different angles. And so it's a place where you can find somebody who knows maybe how to navigate that trademark space also, and get some advice on that. We also support specifically women's business centers. And so since this is the Women's Entrepreneurship Symposium, I would be remiss in not calling out the women's business centers specifically, but that is a fantastic place to start. And so these are community-based centers that help with training, mentoring, referrals. They help you broaden your network and tap into many of the resources that exist out there. And then also, we also support veterans business outreach centers. So if you are a current former member of the military, one, thank you so much for your service. And two, we want to help you transition out into starting your own companies as well. And so there are great training programs through the Veterans Business Outreach Centers. So SBA supports this huge resource partner network, and this is to get on the ground. And I realize, now we're primarily operating remotely, but it is really helpful often to find who is that local person that can tell you how it's done even in your state or city. Maybe there's some special programs that your city actually does to help support small businesses. And so the place to go for that is sba.gov. If you remember nothing else, hopefully it's sba.gov, local assistance, but you can find partners you can help that will help you navigate this whole complicated business of starting a business. And then once you're ready for the funding side, I think we'll probably talk more about that in the next round once you've started your business.
Thank you, Jennifer. That was a lot of information, very helpful. We'll turn it over to Jennifer Hartchick. And Jennifer, give us a little bit more information on what our hypothetical Heidi's hovercraft is, what Jason mentioned. What does that our hypothetical person need to do on the patent side?
Yeah, so as you're thinking about everything that Jason talked about, you're thinking about branding, and Jennifer talked about, you're thinking about starting a business. What else should you be thinking about? On the patent side, you should be thinking about protecting your new invention, that new motorcycle, that hovering motorcycle that is brand new, no one's seen before. How do you do that? The way to do that is to file a patent application. So if a patent is granted, it is a federal intellectual property right that provides protection to the owner. The owner of a patented invention can prevent someone else from making, using, or selling their claimed patented invention. So you've spent all this time, all this resources. You don't want someone else or a competitor sweeping in and taking that invention away from you and putting it out on the marketplace first and capitalizing on your hard work. So start thinking about, should your invention be patented and protected in that way? One of the things you would start to look at is, is your invention new and unobvious? So meaning in the ordinary skill in the art, someone in that art, is it something that's new, that's not known, not done by anybody else? And is it unobvious? Like, it would not be obvious based on combining other inventions that are out there. So in this case, Jason has set it up. It is new. He doesn't know of anything else out there. Finally, a hovering motorcycle. And so patent application is the way you'd want to go to protect those rights. There are several different types of patent applications. So the first type of patent application to consider would be a provisional patent application. So this is an application that is used and basically as a placeholder to reserve your filing date. The US patent system is a first inventor to file system, which means the first inventor to file a patent application has the presumption of having superior rights over anyone else who files a patent application for that type of invention later on. So you file the provisional application. One of the things with a provisional application, it is a placeholder per se. It does not actually get examined by an examiner. However, it gives the inventor 1 year to make a determination of what should they do. Should they continue on? And they can also get that earlier filing date. As I said, filing dates are very important. If you want to be that first inventor to file, you can file a provisional patent application. After 1 year from the filing date of a provisional application, it automatically expires. So as the inventor, you could have 1 year to think about, should you continue on in this process? You could do a little more investigation. Is it already out there? Maybe it is, but you don't know. But if it's not, what do you do then? The next thing you would do within that 1 year period in order to claim the benefit of that earlier filing date on the provisional application, you would file what is called a non-provisional patent application, which is also known as a utility application. So you are claiming in that application a new and unobvious invention. It could be an article, it can be a method of doing something, it could be a chemical composition, but in our situation, it is that new product, that new hovercraft motorcycle. And so that is something that will get examined by an examiner. So there you put in a very thorough and detailed explanation of what your invention is. There's things at the end we can discuss later as well that's called the claim. So what are you claiming as your invention? Now, motorcycles are out there, so you can't necessarily claim those features that are already out there. But of this motorcycle, what makes yours new over what is out there? And so that's where you would use that in forming your claims of what you are claiming is your particular invention over the prior art. And the prior art is basically anything else that is out there, other patents, other patent applications, other inventions that just may be out there that someone could search for on an internet search provider. And so that's the thing you want to do. You don't have to file a provisional application like I discussed earlier. If you know that your invention is new, is unobvious, you don't need that extra 1 year time frame to consider anything, you can file a utility application, or also known as a non-provisional application, first. You don't have to file the provisional application, but the provisional is there in case you need some little extra time to help you develop what you're working on, or to look and see. Some people use it to see if it's really a marketable product and if you want to go forward in this. There are also two other types of patent applications that aren't as commonly known. One is called a design application, and that protects the aesthetic appearance of a product. So in our example, that motorcycle, the hovering motorcycle, maybe it has some unique lines or a unique shape that gives it that capability. And you want to protect that look, that shape of your motorcycle. So a design application would be something that you could also file. So you could file a utility application and a design application, because both protect something different. The utility protects the use of the invention, and the design protects the look of your invention. I know there's a lot of design applications in maybe like in soft drinks. If you recognize a particular shape of a bottle that you associate that with a particular soft drink, you may want to, people have used that. They can be used in all different ways. So those are two types that you may want to consider. There's one I'll mention, it doesn't really go with our hypothetical, but another type of patent application is a plant patent application. So as you figure, there's many growers out there that they've come up with new plants. So they've did the reproduction, they've made it in their greenhouse, and it's different. It's a hybrid or something compared. It's a new type of flower. It's a new type of vegetable. It's a new type of plant that grows better. As long as they can reproduce it, then you could obtain a plant patent application. So if anybody is gardeners or growers, if that's your field, that would be something to consider as well. So those are the four main types of patent applications that you want to consider as you're thinking about branding and forming a small business for your invention. I think later on in the program, we're going to talk about what do you actually do to obtain a patent application, to obtain a trademark application, which ultimately, hopefully, results in an issued patent and a registered trademark.
Thank you, Jennifer. Ben, what thoughts do you have, or top advice for business owners and resources that you can share light on for our hovering motorcraft?
Right. I'm going to ask Jason to take a look at our trademark, Heidi's hovercraft, and perhaps he can give some advice on how we choose trademarks. Because what I found in this is when you're dealing with someone that started a new business, they're really good at what they do. We're talking about entrepreneurs. They're good at finding ways to fix problems. They're good at business. They have all of these things that have their mind focused on what they're doing. And I've sat on these panels before where it wasn't focused on intellectual property, and these people jump so quickly from step to step because they're always thinking ahead. It's like, okay, I want to do this, and then where am I going to distribute, and how can I expand my market to here? And their brain works so quickly, they're ready to get out and sell. And so part of the reason for all of these resources is to get people to slow down and realize you've got some assets here. And it's not just whether or not they have a trademark or patent, it's that they need to recognize that they have one. So not only do they need to file for a trademark or put in a patent application for their invention, they need to realize that they have something that's protectable. So many times I hear things like, yeah, I invented this something or other and I need to get a copyright on it. So knowing what kind of intellectual property a new business owner has is very important. So one of the ways that we kind of address the new business owner, the entrepreneur, and even consumers is through our Stop Bakes roadshows. And stopbakes.gov is our website, so please visit it. Any of the resources that I talk about, you'll have a links at the end of this presentation, so don't worry about remembering where everything is. So we have these roadshows where we gather together all of the agencies that the U.S. government has that has a primary interest in protecting and promoting intellectual property. And we do this by putting on one-day seminars where we go around the country to different cities and we will talk about patents, and we bring the PTO in to talk about patents. We talk about trademarks, and we've been lucky enough to have Jason come in and talk about trademarks. We have the Copyright Office there. So we have someone to tell you about how to identify your copyrights and how to register those. We have people from Customs and Border Protection. Most people don't know that they can actually have their stuff protected from having counterfeits being imported into the United States. So we have Customs there to talk about the recordation process. We have the FBI there. You say, what is the FBI going to talk about? Trade secrets. Trade secrets are very important. To some businesses, it's their whole business. They may decide that they're not going to file for a patent because they can keep their valuable invention or process secret. And so no one will find out about it. So the FBI talks about, the threat of having your trade secrets stolen and what steps you need to take to protect them. We have the Department of State that talks about our embassies and how we strive to protect U.S. business interests overseas. And back to the Department of Commerce, we have commercial officers in most embassies around the world. And we also have people in the United States in what's called U.S. Export Assistance Centers. And that is who we partner with when we do our road shows. So the commerce folks, the commercial officers, have tons of information about just good practice with how you find distributors. They can check in export markets for you and tell you what the best ones are. We have things called top market reports. So a lot of assets there. The roadshow is our main entrance to talk to SMEs, small and medium-sized businesses, just to let them know what they have and then how they protect it. So the roadshows are fun. We get to meet people one-on-one, talk to them face-to-face. And some of the assets that we provide at these is businesses that go to these can actually, at the roadshow, talk to Copyright Office representative and apply for copyright registration right there at the roadshow. And we've had a few of those. And we've had people work with the Customs and Border Protection people to apply to record their marks with Customs right there at the roadshow. And we've had a few of those that have been successfully recorded. So there's a lot of stuff out there, a lot of resources, and it's because this stuff is important. Small businesses are what's driving economic growth and job creation, and we're here to support it. So we have a number of assets on stopfakes.gov, which include we have something called the IP snapshots. So if you've made your business and now you're ready to start exporting, we have a document that will let you look and see what is it about this country that's relevant for intellectual property protection. So there'll be a list of IP treaties that they're members of. It will show contact information for the IP offices in that country. It will list something called whether or not the country was listed on what's called the Special 301 report, which is a report that the United States Trade Representative puts out every year talking about whether or not different countries are protecting intellectual property. So lots of good information. I think I'll save the enforcement nightmares I get for later in the conversation, but so there's lots to do and lots of information out there. So finding it is often the difficult part, and we're trying to make that easier.
Thank you, Ben. So we've introduced our hypothetical business owner to your programs. What can a small business owner expect once they decide to participate in your program or file for intellectual property protection? We can start with Jason again.
Yeah, sure. So, and by the way, I'll just say for those of you, Ben was talking about stock fakes. If you have an opportunity to go to one of the road shows, I would highly recommend it. They're really just a great way to meet with representatives from all across the federal government and to learn, because we're all doing presentations, and so you're learning the basics. And so I highly recommend those. So let's say you are, you've got Heidi's hover cycle, and you've been doing your research, and you know that there aren't any potentially conflicting marks out there because you've done your clearance search, and you've done some more work in terms of research. Maybe you've attended our Trademark Basics Boot Camp, which is an 8-week series that teaches you pretty much as we possibly can about the entire process that I'm going to talk about in just a couple of seconds. You've attended the boot camp, so you've learned lots of things. You've looked at our resources online, and you realize, yes, this is the trademark that I'm using for my product here, and I want to get protection for it nationwide. So what do I do? How do I go about doing that? Okay, so let's say it is Heidi's hover cycle, and Heidi has now been selling it for a little bit of time, and she's getting a little bit of buzz, and she's like, okay, now I absolutely need to make sure I get protection. So what do I do, right? So what you would do if you were Heidi is you would go to our website, uspto.gov, and in that little find it fast box that I was talking about on the landing page, you would do the little drill down to get to TEAS, TEAS, which is the Trademark Electronic Application System. And you would file a trademark application And you have a couple of options. One's called TEAS Plus, the other's called TEAS Standard. We always recommend that folks use TEAS Plus because it is cheaper, okay? And there's a reason that it's slightly less expensive, and that is because the form requires you to front load all sorts of information into your application. It's stuff you're going to have to be putting in there anyway, right? So it kind of makes sense to just put it in there first, because, and then what that does is it creates efficiency, because it's efficient for you because you won't have to put stuff in later, and it's efficient for our office because that means that the examining attorney who is assigned to your application has all the information right there at the ready. All the materials are right there, and she can go through and take a look at all of them and say, yes, you can register your trademark, or maybe not yet. There's some things we have to fix. Okay, so what you would do is you would submit an application, and then it would go through the examination process. And folks will often ask, what's the deal with an examination process? Why isn't it that I automatically have a trademark registration? Well, that's because here in the United States, trademark rights are based on use, and because through the examination system, we have to make sure that nobody else out there is also using a same or similar mark for related goods and services, and that your trademark complies with all sorts of other rules and regulations and things that are defined by statute. All right, so there is that examination process. So once you've applied, your trademark is going to be examined, and there might be some back and forth between you and the examining attorney about whether or not the application can go forward. And let's say that it can. Okay, it can go forward. You've done everything correctly, and so the examining attorney will do what is called an approval for publication, and that means that your trademark application is published in our official gazette, which is a weekly publication that has a listing of all of the trademarks that have been approved for publication. And it's a way to put the public on notice that, hey, this is my trademark. I'm Heidi's Hover Cycles, and this is my trademark, and I'm claiming this trademark for use with my motorcycles that hover off the ground. Okay, so it goes through a 30-day opposition period, and provided everything is fine and nobody who has reason to opposes your trademark then would move on to registration. Now, there are lots of other sort of neat exceptions and other little filing bases that you could be using, but that's the basic sort of model, okay? You would apply for registration. It goes through an examination process, goes through the publication for opposition process, and then if everything's A-okay, you get your registration certificate. And as I said, it's not immediate, okay? That takes some time. And the quickest that I've ever seen an application go from beginning to registration is probably somewhere in the 7-month range, somewhere around there. 7 or 8 months is probably the quickest, just based upon, that's how things work. Sometimes trademarks don't register at all. All right, because it could be that, let's say you have a soft drink and you have tried to register, Coca-Cola spelled with Q's instead of C's. Do you think that's going to go forward? No, it's not, because it's going to cause confusion with Coca-Cola, right? So your trademark registration is going to be refused. So at that point, you're not going to get it at all. So the fastest could be 7 months. The longest could be years. I mean, when I was examining, there was a case. I remember that it came out of suspension. It had been suspended for quite some time, and I think it had been around for about 10 years. So it can take a long time for something to work through the process. And as I said, there is no guarantee that it will, but probably somewhere in the 12 to 18 month range. That's probably about right, probably about average for how long it takes a typical trademark application to register. And there are lots of other little tweaky things that I could talk about in the process, but that's the sort of main thing. So that's something you want to think about, right? As you're starting your business, you're growing your business. How long is it going to take to have my trademark protected nationwide? How long is it going to take before I can start to use the little R in the circle symbol? Well, it could take quite some time. But the interesting thing that you might want to think about is that there is no law that says you have to register your trademark with us, okay? You could, if you wanted to, rely on what are known as common law rights. And those are rights that are created under state law, and you could, if you wanted to, never, ever, ever apply for federal trademark registration. You could do that. However, you miss out on a lot of benefits that come along with federal registration, and I can talk about that a little bit later. But remember, it is your choice. Okay, and because the thing is, and the reason I bring that up is that even though it might be taking 12 to 18 months for your registration to go through, that doesn't mean that you're vulnerable necessarily during that time period, because you could still rely on those rights. And you could always point out, hey, I see that you were trying to use Heidi's hover cycle for a brand for your hover cycles. Don't do that. I have an application filed with the United States Patent and Trademark Office is going through the process, right? So you can also let people know and try and get them to stop using a conflicting mark based upon the fact that you have an application in front of us. So sometimes people are like, oh, do I have to get the registration first before I even go to market? No, you don't necessarily. Now, you know, there are little trade-offs there, but you don't necessarily have to have that registration, the R in the circle, before you actually go to market. It is really your choice, and it's based upon the business decisions that you want to make and the things that are most important to you. So that's a little sort of overview of the process. It's obviously way more complex than that because it's a legal proceeding, and so there are lots of ins and outs. But that's the sort of basics of the process anyway. So once you've said, yes, I've got my business up and going and I want to protect my trademark, that's the sort of process that you would go through. Filing that application through our website and then working with the examining attorney to hopefully get to registration.
Thank you, Jason. I know you'll go over this in more detail in our next segment, but can you quickly let our hypothetical filer or business owner know if they should be worried when they're denied at their first try with their application?
Great question. No, you shouldn't necessarily be worried because it's pretty much common that most applications are going to get what is known as an office action. And that's essentially what happens when the examining attorney looks at your application and says, okay, for the most part, it's okay, but there are a couple of issues that we need to work out. And there are various flavors of office action that you might get. One is the big sort of like letter that says your mark is refused because it is Coca-Cola spelled with Q's instead of C's, right? So that's the bad version that you don't want. But the other versions are kind of nicer. There's, for example, you might get a phone call or an email from the examining attorney that says, hey, you know what? Everything is looking great with your application. There's just like this one issue that we need to clear up. And then you can have the conversation with the examining attorney, and the examining attorney says, great. I will send you what is known as an examiner's amendment, which memorializes the conversation, makes a change in the record. You don't have to do anything at that particular time because the examining attorney is taking care of everything. And so, and then the examining attorney can approve your application and it'll move forward from there. So yeah, but probably will be communicating with the examining attorney. I think if I'm remembering the sort of stats correctly, I would say, I think it's around 20 to 30% of the time somebody who files T's plus gets the initial application approved without any back and forth with the examining attorney. Okay, so that's like 70 to 80% of the time you're probably going to get an office action. Okay, so using T's plus helps your odds of maybe not getting the office action because you have to do everything kind of correctly the first time. But don't be concerned if you get that office action. You can make sure that you read the office action, understand it as best you can, follow the suggestions the examining attorney puts in that office action. But if you still have questions, you are welcome to contact the examining attorney in your case and say, hey, you know what, I understand these things, but I'm a little lost on this. Can you help me understand this? And the examining attorney here at the office, everybody, they're awesome. We just have such great examining attorneys here. They'll work with you to help you to make sure that you understand what's happening in your application. So don't be concerned if you get that office action because it doesn't mean you're dead in the water and you still have another bite at the apple.
Thank you. Those are all great advice, and that's really good to know. We can continue along with talking about intellectual property. Since we're on the USPTO, we can have Jennifer Harchick discuss just the process. You know, I know from the patent side, the application is classified during pre-exam, then it gets to the examiner. what else can our person expect?
Yes, thank you, Heidi. One thing before we get into that, I did want to mention, Ben had mentioned another type of intellectual property right, trade secret. And so I just wanted to give a little bit of background between the difference between trade secrets and patents, because they are two different types of intellectual property rights, one at either end of the spectrum. So a trade secret is basically what the name says. It is a secret. It is your invention, you're keeping it secret, you're keeping it close to the vest, you are not disclosing it to the public. That works for certain inventions. It may not work so well with our hovercraft motorcycle invention, because if you make that motorcycle, a good mechanic can probably take apart that motorcycle, find all the components, find all the pieces, see how they fit together, and see how it's made and replicate it. And so then the secret is out. Once the secret's out, it can't go back in. It can't become a secret again. A trade secret may work well for other inventions. Say maybe you have a new type of cleaning composition, and what in components in what quantities in that cleaning composition may not be easily obtained from a review, or maybe even a chemical analysis. Maybe someone can't figure it out. That might be something that you may want to consider as a trade secret. You keep it close to you. You don't tell anyone what's in it, how to use it, how to make it, and it stays a secret for as long as it stays a secret. So, once someone else learns about it and it gets out, then it's out and it's no longer secret. However, the opposite of a trade secret is actually a patent. If someone obtains a patent, that gives the owner a 20-year monopoly to prevent others from making, using, or selling your claimed product. So, for example, in our motorcycle example, that may be the avenue you want to do, because someone could look at it, take it apart, and they could easily figure out what it is. However, in order to obtain that 20-year monopoly and have a patent, the inventor must disclose every aspect of their invention. They must disclose all the components, how the components connect together or relate, how everything works. So it's a balance. You get that 20-year monopoly. However, you must disclose to the public how others can make and use it, but you have those rights for 20 years. After 20 years, the invention is then called what's dedicated to the public. So that's kind of a little background on the difference between patent and trade secret. So Jason talked about getting a trademark registration, filing the application. There's the same process on the patent side. You have to file a patent application that there's various components to it and disclosing every key feature of your invention, how it goes together, and then at the very end, we've mentioned claims before. What exactly is the invention that you are claiming? What is special about your invention, and what is new and unobvious compared to other motorcycles that are out there? Jason talked about the examination process. On the patent side, it can take a little longer. There is a backlog. I'm not sure exactly what the current backlog is, but sometimes the examination process could take, over a year or even sometimes several years, depending on what the art is. So one of the first things that happens is, Jason mentioned, in office actions. The patent examiners will also issue an office action. I think he said probably about 20% receive an office action on trademarks. A majority of applications receive a first office action in patents. When I was in private practice, I only ever had one application that did not receive an office action, and the first action was a notice of allowance saying, yes, there's claimed patentable subject matter. And I tell you, my office scrutinized that application more closely than any other applications to make sure, did we get broad enough protection for our client? But so, don't worry if you receive an office action. That is, again, a communication from the examiner. And what they do is they do a search. They'll do a search and compare that to your claimed invention and determine, they'll say, well, your invention isn't new, it isn't unobvious because of these patents that are already out there. Now, then what you have the opportunity to do is come back and do a communication back to the examiner and say, well, wait a minute, no. My invention is different and new, and it is not disclosed in any of these references because, and then you list the because. And it can be a back and forth conversation through written communication with the examiner and to determine if there is patentable subject matter. And so that is on the patent side. As Jason said, on the trademark side and on the patent side, you can file these applications yourself. You are authorized to represent yourself before the office in these patent and trademark applications. Both patents and trademarks have assistance centers that can help you. So if you so choose to represent yourself, now they cannot provide legal advice, but they can help you navigate the system a little bit, the process. But if it comes to what should I do or what are my legal rights, they won't be able to go that step. If you decide you need legal advice or you just don't want to file the applications yourself, you want legal counsel, there's several ways you can do that. One, there are practitioners in private practice who specialize in trademark prosecution. Also, there are attorneys who are registered. You always want to make sure you use a registered patent practitioner for a patent application. These are people who are authorized to represent others. Now, what happens if you are an individual or a small business and maybe you don't yet have the resources to pay for the service of a trademark attorney or a patent attorney or patent agent? The office oversees and administers two programs. I mentioned it in my introduction. One is called the Law School Clinic Certification Program, and the other is the Patent Pro Bono Program. Both of these programs provide intellectual property services to qualified individuals as part of the USPTO's Pro Bono initiative to help those who may not have the resources to obtain patent services who really could use these services. So both services provide their legal fees for free to qualified individuals. The individuals or applicants would just have to pay the USPTO filing fees and any other fees that are associated with the application, but their legal services are free. The difference between these two programs is on the law school side, we have 60 participating law schools. The law schools provide patent services, trademark services, or both. So you could receive from either. In this case, each of the law school clinics has a authorized person who is the supervisor, who is a qualified individual to either is licensed to practice trademark law or is a registered patent practitioner who is authorized to provide patent services to others before the office. So all the schools have a qualified individual. On the law school side, again, as it is, it's a law school program. So students enroll in the clinic each semester and they work with supervisor to help provide those services to the public and to the client. So it's also a learning experience for the students. As I said, there are 60 law schools that provide these services, and some of them have restrictions based on their geographic service area. Others serve clients all throughout the United States. So that's a little overview of the law school program. The Patent Pro Bono program is another pro bono program. It only provides patent services. So there are 21 regional programs that provide coverage throughout the entire United States. And what the regional programs do is they seek volunteer patent practitioners to donate their time and provide these services to the qualified applicants through the patent system. And so there's a series of steps that an individual would need to go through to see, do they qualify for the patent pro bono program? And if they do, they are paired up with a registered patent practitioner who will work with them to draft a patent application, file it, and go through the prosecution phase that we discussed. So that's a little overview about both of those programs.
Thank you so much, Jennifer. Ben, can you let us know what they should expect when they contact stopfakes.gov, or even just your general, just other aspects of your program? What should they expect once they participate and file for help?
All right, so we have our business, and they've followed all of the advice they learned today. They have their trademark, they have their patent, and guess what? It was a genius idea, a hovering motorcycle, and we are making money. So now, if I'm at the roadshow, I'm probably going to ask the participants, okay, what are we going to do now? We've got it. It's going to make a lot of money. Where are we going to sell? And they said, okay, well, we want to try to get it on Amazon. And I said, are we going to what other countries do we want to sell? Okay, well, we want to sell in Canada and Mexico, and they'll have their list. And here is a real world example of what I get. First of all, what's going to happen when we're successful? So everybody that just looked at their screen and said we're going to get ripped off, you're 100% correct. Yes, if you have something that makes money, eventually somebody's going to copy it. So the question is, how do you try to protect it? And a lot of people that we deal with, the small businesses especially, they've got their US patent, they've got their US trademark, but guess what? That only protects you in the US. That's probably the most important thing I could tell anybody today, is that even if you went through all this work and you've got your US patent, you've got your US trademark, it's only going to protect you in the US. So if you want to go sell in foreign markets, then you have to get protection in those markets. And we have an email address, stopfakes@trade.gov. You'll see it at the end, where people can email in their IP issues. And 80% of the emails that I get every day are consumers reporting different sites they see selling counterfeits. But every once in a while, probably once a week, I'll get an issue from a business, and usually I'll pick up the phone and I'll call them, and this is an example, a real world example of what I'll usually hear. And it'll be, look, I started going into a contract with a company in Australia, and I was going to supply them my widget. And we went back and forth on price, and all of a sudden I didn't hear from them again. And then I find out that they're selling my widget in Australia. So he picks up the phone, he calls the guy, and he says, well, you still want me to be your supplier? And he's like, no, I can get it for cheaper in China. So in his mind, he's like, my widget is being stolen, but it's not his widget in Australia, and it's not his widget in China. So it's important that you look at not only where you want to export, but we always tell people, always look at the kind of the main offenders. Where is it likely to be ripped off? And of course, China is one of those. And it's not picking on China. 86% of the counterfeits that are seized at our borders come from Hong Kong or China. It's pretty much the same every year. So you can actually get protection in those countries. One of the things we have on our website, we have these toolkits for different industries, and the information on those toolkits is ways that you can get intellectual property in other countries using these efficiency tools, which are some treaties. The nice thing about these treaties is a lot of them you can go through the USPTO. So we have the Patent Cooperation Treaty for trying to get patents in other countries. That can be done through the USPTO with your US patent. Same with trademarks. We have something called the Madrid Protocol, where if you have a US trademark, you can apply for other countries. we have information on all this stuff. The USPTO has it on their website. So there are tools that people can use. So the main thing is it's going to happen. The bottom line, most of the time, these are private rights. So businesses are responsible for protecting their own intellectual property. So I'll leave it at that.
Thank you, Ben. So we have our person knows a lot about their trademarks. They know that they should file internationally. They have their idea of what they may do patent-wise. But Jennifer, they're still, trying to form that small business because they have to get it in commerce in order to use the trademark and to get the value out of, the patent filing. What would they, once they participate with the SBA, what's the process? Is it grants, tech transfer? What does that look like for them?
Yeah, thanks. And, this is going to be completely different because, when you're filing for trademark and patents, both Jennifer and Jason mentioned the fees. And as a small business owner, that's one of and an inventor, it's just one of your main concerns. Where am I going to get the money? How am I going to pay for these things? How do I find the money to run the business and pay for the protection? And so I'm going to focus in on that $4 billion seed fund I mentioned at the start, which is the SBIR, Small Business Innovation Research, Small Business Technology Transfer Programs. That money is for doing research and development. So these are both grants and contracts. And one of the things that's really complex, I think, about the program is that it's really 11 different federal departments. Any federal agency you think of that funds science, so Department of Defense, National Science Foundation, NASA, Department of Health and Human Services, NIH, the U.S. Department of Agriculture, they all support small businesses in furthering their R&D. And there are a few really key pieces related to intellectual property here. One is that when you apply for a grant or a contract through the SBIR program, that is not considered, I'm blanking on the word, maybe Jennifer can jump in here, but it's not disclosure. So it won't harm your ability when you apply for a grant or a contract. So if you don't have your patent protection yet, that's okay. The other piece is that there is, while all of the funding that goes to support that research and development project is for the R&D, there is a special provision that came in recently, actually, called technical and business assistance, which is up to $6,500 in the first phase of these programs. I guess let me give one step back, which is the SBIR and STTR programs it's tranched and phased funding. So there's an initial phase 1 proof of concept type of funding. So this can help you. You've got an idea, bring it to a prototype stage, or you have a prototype, let's test it out a little bit. And so that's what that phase 1 funding is for. It's typically somewhere between $50,000 and $250,000. And then there's a second phase once you've gone past that phase 1 proof of concept to do further research and development. And so phase 2 is $750,000 up to somewhere, almost $2 million, so $1.7 million. And then really that's to get you to de-risk that technology development so that you can do the work that will also help you develop the patents. And you can also do more to protect your intellectual property during this time period to possibly sell or license it later on as a possible exit for your business. But one of the things that I started to talk about was beyond that, $250,000 in phase 1, you can have up to $6,500 that can help support you either paying, some of the licensing or not licensing fees is a possibility, but patent fees, or for a consultant to help you with this. and it's actually up to $50,000 in phase 2. So there's funding available. There's also in-kind services that a lot of the agencies offer to help support your ability to do this. And then one of the really key things about getting funding through the SBIR or STTR programs is that it comes with something called SBIR data rights protections, which means that those agencies cannot reveal anything about your data that you developed through these grants and contracts. And so that allows you, if you want to use trade secret as your mechanism for protecting your intellectual property, these data rights protections allow for that to also happen, and that will be maintained. So I know that there's a lot about SBIR that I could go into much more in depth, but there are mechanisms, and we'd like to collaborate with USPTO on all of the valuable inventor resources available there. But this is where you can find some money. So sbir.gov. And you can find many resources there as well to find, I mentioned the SBA Resource Partner Network on sbir.gov. We also have a specific area focused on finding local assistance dedicated to those entrepreneurs who are focused in research and development.
Thank you, everyone. This has been a very informative panel. We have, I guess we can try to take 1 minute, maybe, if you can, say in one sentence, the best advice you can give our business owner as we wrap up.
Sure, I'll start off. So I would say the best advice is to educate yourself. And with regard to trademarks, one of the best ways to educate yourself is to go to uspto.gov and take a look at all the resources we have there. Please sign up for our Trademark Basics Bootcamp. You'll see my big greasy forehead like every single Tuesday for 8 weeks, and you'll learn everything about trademarks. We also have a downloadable Trademark Basics booklet, which is really, really helpful. We have lots of trademark videos that are available, and we've recently learned YouTube allows you to auto-translate that into other languages. So even though everything we have up is pretty much English language based, you can use YouTube's auto-translate feature if you don't speak English as your first language. Another great resource as we wrap up is to remember, and Jennifer mentioned this, the Trademark Assistance Center. And this is our customer service division at Trademarks, and they love to help you. They want nothing more than to help you. And you can give them a call, you can shoot them an email, and they, of course, cannot give legal advice. No one at the USPTO can give legal advice, but they can give you general information. So that would be my advice. Educate yourself as much as possible about trademarks and the registration process, and that's going to help you so much when you file your application, and your application is going to sail right through.
I will echo what Jason said. Definitely educate yourself. On the patent side, there is something that Jennifer also alluded to that's called disclosure. On the patent side, there is something, if you disclose your invention to the public, that starts the clock running for the time that you have to file a patent application. And if you do not file a patent application within that time from disclosure, your invention is then dedicated to the public. So be careful if you're out at cocktail events or anything like that in what you're disclosing until you either educate yourself or talk to a licensed practitioner that can tell you what to do, because the last thing you want to do is take an action that would actually preclude you from patenting your wonderful invention. Again, more resources. I talked about the Law School Clinic Certification Program and the Patent Pro Bono Program. Both of those websites are going to be provided to you at the close of this. However, if you forget the websites, you can go onto the main Patent Office webpage, which is uspto.gov, and in that search box that Jason talked about, type either Law School Clinic or type in Patent Pro Bono Program, and it'll take you to the links and provide you with all the information for those two programs. Thank you.
Jennifer Shee.
Yeah, well, so the key piece of advice is remember you are not alone. There is a ton of help to help you navigate all of these, varied complex programs and resources, and they are free. So that's also a reminder that there are a number of these resources that are free. So SBA.gov for any of the business assistance more broadly, and to look for money to SBIR.gov.
Okay, yes, for a lot of companies, the most important thing is going to be your intellectual property. So absolutely protect it. You know, we operate under what we call the no wrong door policy. So if you have any questions, any issues, you know, email whoever you know. And, you know, we work closely together. We will make sure that we get you to the right person. So if you have a question on Stop Fakes and you only remember Jason and his email, he can, you know, get you to me, and I can help you with whatever it is you need. The takeaway, you know, get your intellectual property, and just remember, U.S. patent, U.S. trademark only protects you in the U.S. So you've got to look at protecting yourself before you export. And then stopfakes.gov, please. We have lots of information there, and my email is on the follow-up slide, so feel free to ask me any questions.
Thank you, everyone. This concludes our discussion. I want to thank our panelists today. You all provided wonderful information. The discussion was robust. I hope everyone takes on that good lasting advice and gains something from this event, and want to thank Sean Wilkerson and Nathania Ferguson and the rest of the Office of Outreach and Innovation and Outreach. Thank you so much for putting this program together. And that's it.
Thank you, Heidi. And thank you, Ben, Jason, Jennifer, and Jennifer for today's discussion. All of this is great information. And if you have any questions and you need to reach out to us, you can reach us by email at www.uspto.gov. You can send us your questions. We will get those over to the panelists and assist you with finding the right information for you. If you missed any of today's program, we will be posting this program online in the next few weeks. But if you're ready to watch the program again because you wanted information right away, you can log on to our Facebook page for USPTO, where the program video is available and ready for you to view directly after the program. At this time, I'd like to introduce you to Nathania Ferguson. She's the Office of Innovation Outreach Manager here at USPTO, and she'll be closing out today's program. Nathania, I'll turn it over to you.
I'm sorry, I was muted. Good afternoon, everyone, and thank you, Sean, for the introduction. And I want to also thank our moderator and panelists for providing that informative discussion about government resources that are available to support inventors, entrepreneurs, and small business owners. For today's wrap up, we want to make sure you have information to follow up on resources that were discussed today. First slide, please. So we recognize that it's not cheap to have an attorney prepare, file, and prosecute your patent application. So we are always happy to share information about 2 free legal services provided by either a patent practitioner or law student. First, the Patent Pro Bono program, which you heard Jennifer speak of earlier during the discussion, is designed to help inventors and small businesses with limited resources that need help applying for a patent to protect an invention. You can visit the Patent Pro Bono webpage at uspto.gov, Pro Bono Patents, all one word. Once you get to the webpage, you can learn about the criteria to participate in this program, and you can also access videos that will explain how the program works. There's a video in English, and there's also a video in Spanish. Second, we have the Law School Clinic Certification Program. As Jennifer mentioned, it's a nationwide program. There's 60 law schools participating. This is another option for pro bono assistance. As mentioned, students practice under the guidance and supervision of approved faculty that is experienced with filing and prosecuting patents before the USPTO. Please visit uspto.gov/law school clinic, all one word, to get more information. Next slide. Next slide, please. As we've heard, the patent process is complex. There's various laws, regulations, policies, and procedures, and therefore we always recommend using a registered patent attorney or agent to assist you with preparing your application. However, there is not a requirement for you to have an attorney. If you decide to file an application on your own without an attorney, you will be considered a pro se applicant. And the good news is we have a pro se assistant program here to help you. The program will not provide legal advice, but the dedicated pro se assistant team will provide you with information so that you can be successful in filing your patent application. Please check out the Pro Se Assistant webpage at uspto.gov, Pro Se Patents, again, all one word, to learn more about this great program. You can access educational materials and even set up a one-on-one appointment to answer your specific questions about filing a patent application. Next slide, please. So we also have free resources to help you with protecting your brand. The Basic Facts About Trademarks booklet contains a wealth of information about trademarks, such as things you should consider when selecting a mark, tips on searching on trademark searching, and links to free resources to assist you with your trademark search. There's also these great USPTO videos for trademarks, and those are found at uspto.gov/TM videos. You'll have an opportunity to see more of Jason and hear his great voice if you check out some of those videos. They're very educational, and they'll give you information about the various stages of the trademark process before you file, during, and after filing your application. Next slide, please. So our great friends over in SBA and these wonderful resources that they have that are available to you. We heard how SBA works with a number of local partners to counsel, mentor, and train small business. The first link you see here will take you to a page where you can search for local organizations that are available to you. If you are interested in America's Seed Fund, SBA Small Business and Innovation Research and Small Business Technology Transfer, also referred to as SBIR, STTR programs, the second link here will take you to a page to search for organizations that will provide training and support for those programs. For more information about the unique and important data protection accorded to SBIR, STTR firms, please check out the link in the third bullet. If you are interested in receiving emails from SBA tailored to your role in the research and development innovation ecosystem, please use the link in the last bullet on this slide to sign up for the monthly Americans Seed Fund update. After signing up, SBA will send you information about opportunities, programs, events, or other items of interest to you. Next slide, please. The stopfakes.gov roadshows. Oh, they're amazing. I'm hoping that you all will have an opportunity to attend. They are virtual for the meantime, and they deliver critically important information about intellectual property to inventors, entrepreneurs, and small businesses. For more information, they also have a marketing link here. You just go to stopfakes.gov/roadshows. I know that Ben also made reference to the IPR toolkits, which are also accessible via the stopfakes.gov website. And those toolkits provide resources to help U.S. businesses protect and enforce intellectual primary rights in specific industries and countries. Last but not least, please visit the the stopfakes.gov main page at stopfakes.gov/welcome to access educational resources. We heard from the panelists it's important to educate yourself. You can learn about counterfeits, you can access the business guide for intellectual property rights, and even check out some upcoming events and training. Ben is also very happy to answer any of your questions, and he can be reached at his email, benjamin.hardman@USP. USPTO is on my mind. You know, I'm just a dedicated USPTO employee, so excuse me, Ben. Benjamin Hardman@trade.gov. Next slide, please. I want to thank all of our virtual attendees for spending your time with us today, and I hope you will be joining us for our next 2 WES programs. Registration is now open for next week's program on Wednesday, March 24th. We are so excited about having subject matter experts share valuable information about securing funding for your invention or small business. On March 31st, we will conclude the WES series by hearing from successful women entrepreneurs. For links to more information about how to register for upcoming WES programs, please visit our events page at uspto.gov/events. And while you are on our events page, I encourage you to check out the many other free virtual intellectual property, educational, and awareness programs that are available. You will be receiving a short survey for today's program. Please complete it. We value your feedback. Your input is very important to us as we create future programs to meet your needs. Thanks again for attending today's program. We look forward to you joining us next week. Goodbye.